different than this court requesting member states to arrest and surrender a president. This is where Article 98 and Article 27 differ. But the real question before the court today is, even if there's an Article 98 violation, what is the remedy for such a violation? We see in Article 85 that upon acquittal, President Turk will have the right to apply for compensation. What we are asking the court to do today is to consider the Article 98 violation a material change of circumstance under Article 60, paragraph 3, and that allows this court to review any decisions previously made concerning the detention of President Turk. It is still within this court's discretion, even if it finds there has been a change of circumstance, as how to modify the detention. The defense makes what we believe is a very reasonable request of this court. Under Rule 119, this court, in its discretion, may grant a conditional release.
Counsel, sorry, could you slow down a little bit?
Yes, Your Honor. Under Rule 119, it is within this court's discretion to award President Turk and grant him conditional release. We believe we have three requests to this conditional release. We do not ask that he be returned to the state of Pemba, as we know this court fears that President Turk will not appear for trial. What we ask is that he be confined to house arrest here at The Hague, but given the means, as he does enjoy a presumption of innocence, to communicate freely and privately with the government of Pemba so that he may resume some of his duties as a head of state in the decision-making process in Pemba. And lastly, that Emden government officials be allowed safe passage to The Hague without fear of prosecution or arrest, and be able to meet with President Turk so that he may resume some of his responsibilities, pending whether or not these charges are confirmed. We believe this is a very reasonable request. This court should grant that, as it presents no opportunities for President Turk to flee.
Counsel,
Yes, sir.
don't you think that you are making a request that you should not make him at the state? Isn't this a separate application that you could make at another time?
Your Honor, this court has put it on the agenda today to review the arrest and detention, ensuing detention of President Turk. And under Article 60, paragraph 3, this court is required that this court periodically review these decisions. And we believe that is why it is on the agenda today. And that's why we bring forth our arguments that there has been a material change in circumstance to justify reviewing the decision. But we still submit that it is within this court's discretion in how to modify the detention. And this court need not, under the statute, modify the detention whatsoever. We're merely making a reasonable request, seeing that President Turk has been incarcerated for 11 months, and no additional evidence has been proffered by the prosecution to this point, and the article has not been verified. In addition, the prosecution submitted that EMBA's membership to the Genocide Convention represents an express waiver of immunity, and that's why Article 98 violation does not exist. However, we disagree with that assertion. Article 9 of the Genocide Convention submits that whenever parties to the Genocide Convention disagree as to the meaning of any of the language in the Genocide Convention, this is an issue for the International Court of Justice to decide. And we believe if it is put forth that membership to the Genocide Convention is a waiver of immunity for the most senior state officials for all members of that convention for the rest of time since signing the convention, that this will only have the deleterious effect of the member states withdrawing their membership in such a convention to protect their state officials. And that the International Court of Justice would probably not rule in that manner, saying that membership to Genocide Convention is a waiver of immunity for the rest of time in respect to those crimes. If there are no other questions regarding the second point on the agenda, may I move on to the compulsion of Miranda Phoenix. Under Rule 111, Sub-Rule 2 of the Rules of Procedure and Evidence, it reads, whenever the prosecution or national authorities question a person, due regard shall be given to Article 55 of the statute, and that person must be informed of those rights under Article 55 before such questioning occurs. Specifically, paragraph 1 of Article 55, which applies to all persons involved in an investigation, as opposed to paragraph 2, which would only apply to the accused. Here, Miranda Phoenix does enjoy the rights listed under Article 55, paragraph 1, which states in subsection D that she shall not be subject to arbitrary arrest and detention. In subparagraph B, that she shall not be subject to threat, coercion, or duress. we see that Article 98, we see that Article 93, as Your Honor mentioned, E and F only make available means where the person to be surrendered has given voluntary consent, and even in the case of incarcerated individuals, they must still give informed voluntary consent. It makes no sense to give incarcerated individuals more rights to oppose their surrender to the ICC than people who maintain their liberty and are innocent of crimes. Furthermore, Your Honors, what are the remedies for not complying with the compulsion power of this court under Rule 65? Well, Rule 171 gives only two remedies. First, an interdiction from the proceedings for up to 1 month, and that cannot be sensibly applied in this case. The only other remedy for noncompliance is a monetary fine of up to 2,000 euros per day. This court does not have the power to place a person in detention, such as Miranda Phoenix, for not complying with a court order. However, by having Miranda Phoenix detained and surrendered to the court, they're placing Miranda Phoenix in detention, which is not a power. Even if she refused to comply, the court could not place her in detention. And this is not a reconcilable view with the statute.
So you refer to certain rights to Miranda. You were citing certain paragraphs in Article 67. Am I right?
Article 55, paragraph 1.
55. Okay.
Lastly, Your Honor, we believe that the prosecution will submit that Article 93(1)L is the avenue through which this court can obtain Miranda Phoenix's surrender to this court because it is available through Tonda law. However, we must not interpret it, although Article 93(1)L is intended to give this court a broad cooperation regime with member states, this court should not interpret that certain provision as going against the rights enumerated in Article 55, paragraph 1, specifically the arbitrary detention and arrest. Furthermore, this entire investigation is at the behest of this chamber, not the state of Tonga. Therefore, the rules that govern the investigations conducted by the prosecution of the International Criminal Court should be the rules that govern how Miranda Phoenix is to testify through Tongan authorities. Simply because it is available under Tongan law, we must still make sure that the fundamental human rights of Miranda Phoenix are being respected and that her rights under Article 55 are also being respected. And we feel that she, under the statute, if she categorically refuses to appear before this court, that is within her right. And to ask Tonga to detain her would be an arbitrary detention. As this court, to arrest any individual, must issue an arrest warrant, and that can only be done when reasonable grounds exist that a crime has been committed. That is not the case with Miranda Phoenix. Moving on to the last point on the agenda, Your Honors. The applications of victim applicants K1.
You were saying that Miranda is entitled to refuse to testify before the court?
Yes, Your Honor.
On what authority?
That under Rule 65, this court may only compel witnesses who have appeared. The prosecution seeks to force Miranda Phoenix to appear before this court through Article 93(1)L, and then to use Rule 65 to compel her. But still, this court cannot place Miranda Phoenix in detention for refusing to comply with that court order. Only a monetary fine can be imposed.
Did you have Article 64, 6B? Did you consider that?
Yes, Your Honor. Article 64, 6B does have a qualification at the end of that. The assistance of states as provided in this statute. We must look to the provisions of this statute and see if it is in line with the provisions of the statute. I don't believe, and the defense does not believe, that interpreting Article 93(1)L as allowing this detention of Miranda Phoenix and surrender of Miranda Phoenix, that it would run counter to the spirit of Article 55 and the rights of people involved in investigations.
Furthermore, counsel, in the fact sheet said that Miranda is claiming privilege.
Yes, Your Honor.
Is she entitled